Be cool, be kind, be classy. The cupcakes are sweet and sexy. Have fun, enjoy the journey. Just have a good attorney. No big whoop, no biggie. She lives near New York City. Not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade, sipping motions and lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. Is a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack's at Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Machegas. Ridiculous that insanus. Oy vey, Marcus. Proceed, that's for schmucks. Be cool, be kind, be classy. My cupcakes are sweet and sassy. And not just a YouTube show. When you know, cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Good morning. Good morning, and thank you so much for coming to hang out with me for the first time today. This will not be the only time today, but for the first time today. Today is Tuesday, September 16th of 2025, and Luigi Mangione appeared in New York State Criminal Court in downtown in Lower Manhattan this morning for the first time since February of this year. We started covering this case December 4th of 2024, which was the night of the manhunt before Luigi Mangione was even captured. We covered it live while the manhunt was going on. And I've done a couple more shows on it since then. And today was the first time Luigi Mangione was back in court. This is state court. These are regarding the state charges. You may recall he is also charged federally. But today there was a very short court appearance for Luigi Mangione. I am told that there were a lot of supporters outside the courthouse for him, many of them wearing green shirts representing Luigi, the Mario character from the video game, I guess. 3 whole rows in the courtroom were filled with supporters, and in maybe not such a surprising move, the state court judge has dismissed the top 2 charges involving terrorism against Luigi Mangione. And so I have the papers because that's what we do here. And let's look at the judge's decision. He actually issued a written decision. So let's take a look at the papers and read through. It is 12 pages long. And let us get right to it. This is in the Supreme Court of the state of New York, New York County, Part 32. Those of you from other states may be very confused, but our lowest court in New York is the Supreme Court. That's our lowest court, and then you move up to the appellate courts. It's the second level is the appellate division, and then you have the Court of Appeals, which is our highest court in New York. So the Supreme Court is our lowest court. People of the state of New York against Luigi Mangione, defendant. And this is Justice Gregory Caro, C-A-R-R-O. And this is a decision that was issued today. On December 4th of 2024, Brian Thompson, the CEO of United Healthcare, was shot to death outside of the Hilton Hotel in downtown Manhattan. Video surveillance captured a man wearing a mask, dressed in black and carrying a backpack, drawing a gun, and shooting Thompson in the back and the leg. Video also established that before the shooting, the man drank from a water bottle and threw it in a nearby trash can, that he dropped a cell phone as he fled the scene, and that he discarded the backpack in Central Park. Investigators recovered ballistics evidence from the scene, including 3 shell casings on which depose, delay, and den had been written. Footnote 1 says, likely intended to read deny. Investigators were able to trace the shooter's movements to a hostel in Upper Manhattan, where he had registered using the name and identification of Mark Rosario. And they also found evidence that he took a train to Philadelphia following the murder. Footnote 2. Video surveillance footage showed the man without a mask, both at the hostel and at locations before the shooting occurred. Photos of the suspect circulated on national media. Do you remember? It's Caro, Carro, the judge's name. On December 9th of 2024, the defendant was arrested at McDonald's in Altoona, Pennsylvania, after he was recognized by employees who had seen media coverage. A 9mm gun was recovered from the defendant's backpack, as well as ammunition, a silencer, a fake New Jersey driver's license in the name of Mark Rosario, cash, a passport, and a notebook in which the defendant had made journal entries. There were also 2 letters in the backpack, one addressed to his family and one to the FBI. Ballistics analysis demonstrated that the shell casings recovered at the scene were fired by the gun found in the defendant's backpack. DNA analysis also established that defendant's DNA was on the water bottle found at the scene and on the cell phone and backpack discarded by the shooter. Defendant's fingerprints were also found on the water bottle and on a Kind bar wrapper found near the scene. Defendant was indicted for murder in the first degree, victim killed in furtherance of an act of terrorism, as defined in the Penal Law 490.05, murder in the second degree as a crime of terrorism, Penal Law 125.25(1), 490.25, murder in the second degree, which is intentional murder in New York, 2 counts of criminal possession of a weapon in the second degree, criminal possession of a weapon in the third degree, 2 counts of criminal possession of a weapon in the third degree, criminal possession of a weapon in the third degree, criminal possession of a weapon in the fourth degree, and criminal possession of a forged instrument in the second degree. Defendant has filed an omnibus motion seeking Huntley, Mapp, and Mosley hearings. The defendant also moves to dismiss the terrorism charges as legally insufficient, moves to dismiss the entire indictment for alleged violations of the double jeopardy clause, and argues that the state case should be stayed pending resolution of a concurrent federal case. Footnote 3. Defendant was indicted in the Southern District of New York for murder, stalking, and firearms charges based upon the same incident. The federal prosecutors have filed a notice of intent to seek the death penalty. New York does not have the death penalty for state charges. The people have filed a response consenting to pretrial hearings and opposing the motions to dismiss and to stay the proceedings. The defendant has additionally filed a reply to the people's response, and the people have filed a surreply. The court has reviewed all submissions and decides as follows. Suppression hearings. Huntley, Mapp, and Mosley hearings are ordered. Motions to dismiss. Defendant's motion to inspect the grand jury minutes for legal sufficiency pursuant to CPL 210.30 sub 2 is granted. The standard of review for legal sufficiency is whether there is competent evidence which, if accepted as true, would establish every element of an offense charged and the defendant's commission thereof. Legally sufficient evidence means a prima facie case, not proof beyond a reasonable doubt. A court must consider whether the evidence viewed in the light most favorable to the people, if unexplained and uncontradicted, would warrant conviction by a petty jury. Penal law provisions are generally to be construed so as to give effect to their natural and obvious meaning, particularly where the definition of a crime is not where the definition of a crime is at issue, because the courts must be scrupulous in ensuring that penal responsibility is not extended beyond the fair scope of the statutory mandate. Here, defendant argues that there is legally insufficient evidence of first-degree murder, alleging that the victim was killed in furtherance of an act of terrorism, and of second-degree murder as a crime of terrorism, and urges that the court dismiss those two counts of the indictment. Defendant argues that both legislative intent and case law demonstrate that defendant's actions do not fit within the statute and that the people did not present legally sufficient evidence of those counts. The people argue that both counts are legally sufficient and that terroristic intent was established because the defendant was not engaged in a personal vendetta, but violently broadcast a social and political message that inspired threats to employees of United Healthcare. I see a lot of people asking in the chat. My chat is stopped. Hang on, I don't know. Unlike many other states, I'm just breaking from the document for a second to tell you this. Unlike many other states, New York has very specific requirements for first-degree murder. And I remember all the way back when I was studying for the bar 100 million years ago, I noticed that it was different from many other states because, as you know, I went to law school in Colorado. So there are only certain categories of murder that fall into first-degree murder in New York. Number one is the murder of a police officer. Number two is murder of a peace officer. I'm just looking up the statute. Or a firefighter, EMT, ambulance driver, employee of a state correctional institution. If at the time of the commission of the killing, the defendant was confined in a state correctional institution or was otherwise in custody upon a sentence for the term of his natural life. If the intended victim was a witness to a crime committed on a prior occasion and the death was caused for the purpose of preventing the crime. If you were in the commission of another crime, that was a first or second degree kidnapping, robbery, murder. There are very limited circumstances. One of them is the terrorism exception. But if you're curious, you can just Google New York State first degree murder, and it is different. It's not just intentional murder the way it is in some other states. But here, the state tried to impose the terrorism charges in order to have it rise to the level of first degree murder in New York. We could do a whole separate episode on that, but let's just get through the decision today. But I want you to, there are extensive show notes below this video that give you a brief synopsis of things like how old the defendant was at the time this crime was committed. Here, the defendant argues, I'm not sure where I left off, but here the defendant argues that there is legally insufficient evidence of first degree, alleging that the victim was killed in furtherance of an act of terrorism and of second degree murder as a crime of terrorism, and urges that the court dismiss those two counts of the indictment. Defendant argues that both legislative intent and case law demonstrate that defendant's actions do not fit within the statute and that the people did not present legally sufficient evidence of those counts. The people argue that both counts are legally sufficient and that terroristic intent was established because the defendant was not engaged in a personal vendetta, but violently broadcast a social and political message that inspired threats to employees of United Healthcare. New York's terrorism statute, set forth in Article 490 of the Penal Law, was enacted on September 17th, 2001, just 6 days after the September 11th attacks. The legislature was able to act so quickly because it liberally borrowed from already existing federal legislation. The legislative findings state that the devastating consequences of the recent barbaric attack on the World Trade Center and the Pentagon establish a compelling need for legislation designed to combat the evils of terrorism. The examples of terrorism cited in the legislative findings are 1, the September 11th, 2001 attacks, 2, the bombings of American embassies in Kenya and Tanzania in 1998, 3, the destruction of the Oklahoma City Federal Office Building in 1995, 4, the midair bombing of Pan Am Flight number 103 in Lockerbie, Scotland in 1988, 5, the 1997 shooting from atop the Empire State Building, 6, the 1994 murder of Ari Halberstam on the Brooklyn Bridge, and 7, the bombing of the World Trade Center in 1993. Under Penal Law 125.271, a person commits first-degree murder when, with the intent to cause the death of another person, he causes the death of such person, and the victim was killed in furtherance of an act of terrorism as defined in Penal Law 490.05.1b. Under Article 490.05.1b, a person is guilty of first-degree murder when they engage in activities that involve a violent act or acts dangerous to human life that are intended to intimidate or coerce a civilian population, influence the policy of a unit of government by intimidation or coercion, or affect the conduct of a unit of government by murder, assassination, or kidnapping. Similarly, a person is guilty of second-degree murder as an act of terrorism when he commits a specified offense, including second-degree murder, under Penal Law 125.251, that is intended to intimidate or coerce a civilian population, influence the policy of a unit of government by intimidation or coercion, or affect the conduct of a unit of government by murder, assassination, or kidnapping. The people assert that they have established all three intents, although they focus on intimidating or coercing a civil population. Footnote 4, which says, they also assert that the defendant's terroristic intent can be inferred from the defendant's acts alone. Given the specific language and requirements of the statute, the court is unpersuaded that is the case. Yet they also briefly argue that defendant intended to influence or affect the policy of a unit of government by intimidation or coercion through his actions. There was insufficient evidence presented in the grand jury to support this claim. There was no evidence presented that defendant made any demands of government or sought any particular governmental policy change, let alone that he did so by intimidation or coercion. See People v. Parker, that the defendant was motivated by animus toward law enforcement did not establish an attempt to influence any government policy through his actions. Defendant's statements about need for change were insufficient to establish an attempt to influence a policy as opposed to expressing anger. And that is a case out of the Third Department in 2025. And another case called People v. Jenner, which is a Third Department case in 2007, evidence established that defendants specifically intended to influence Department of Social Services policy. Indeed, as the federal authorities noted, the defendant's goal appeared to be to draw the public's attention to what he perceived to be problems with the healthcare industry. Footnote 5. See the U.S. Attorney's Office, Southern District of New York press release, December 19th, 2024. The people place great emphasis on one snatched phrase, revolutionary anarchism, in defendants' writings to suggest that this satisfies the statutory element of an intent to influence the policy of a unit of government by intimidation or coercion, or affect the conduct of a unit of government by murder, assassination, or kidnapping. Footnote 6. In his notebook, defendant compared himself to defendant compared himself to Ted Kaczynski, the Unabomber, stating that Kaczynski had indiscriminately mail-bombed innocents, thus crossing the line from revolutionary anarchist to terrorist, the worst thing a person can be. And that was quoted directly from his diary or manifesto, whatever you'd like to call it. The people's suggestion that this single sentence established that the defendant intended to influence governmental policy or affect the conduct of a unit of government is not persuasive. See Exhibit A, People's Affirmation in Response. Not only does this stretch the import of a two-word phrase beyond what it can carry, but it ignores other more explicit excerpts from defendant's writings in which he states that his goal is to spread a message and win public support about, quote, everything wrong with our health system, end quote. Therefore, the court finds that the people failed to establish an intent to influence or affect government. This court will focus on the intent element that both sides appear to emphasize, the intimidation or coercion of a civilian population. The court will note that the term terrorism has been famously difficult to define. Footnote 7. The search for a definition of terrorism has been compared to the quest for the Holy Grail. Wow, this isn't the judge's decision. See Perry, The Numerous Federal Legal Definitions of Terrorism, The Problem of Too Many Grails. And another article, Is Terrorism Worth Defining? Some resort to Justice Stewart's comment on obscenity, quote, I know it when I see it. Our Court of Appeals has cautioned against expanding the definition of terrorism beyond what the legislature intended. The concept of terrorism has a unique meaning, and its implications risk being trivialized if the terminology is applied loosely in situations that do not match our collective understanding of what constitutes a terrorist act. The legislature incorporated a general definition of the crime and referenced 7 notorious acts of terrorism that serve as guideposts for determining whether a future incident qualifies for this nefarious designation. As noted above, those notorious acts include the massive death and destruction of the September 11th, the 1998 bombings of American embassies, the 1995 destruction of the Federal Office Building in Oklahoma, and the bombing of Pan Am Flight 103 in 1988. C. Parker, the inclusion of these distinct acts of terrorism underscore the legislature's understanding of the egregious nature of the conduct that constitutes terrorism. In Morales, the defendant was a street gang member operating in a particular area of the Bronx. At a christening party, the defendant fired 5 shots at one of his rivals who was paralyzed. The shots also killed a 10-year-old girl. The prosecution argued that there was sufficient evidence of terrorism because the defendant intended to intimidate or coerce other Mexican-American gangs, and by inference, all Mexican Americans in the geographical area. The appellate division dismissed the terrorism convictions, finding that there was no intent shown to intimidate or coerce the Mexican-American population residing in that particular area of the Bronx. The court also found that members of other Mexican-American gangs in that area of the Bronx did not qualify as a civilian population under the statute, finding that the context of the statute weighed against stretching the meaning of the language to cover such a narrowly defined subcategory of individuals. Examining the legislative findings and the examples of terrorism listed, it was clear that the legislature intended to address extraordinary criminal acts perpetrated for the purpose of intimidating a broad range of people, not a narrowly defined group of particular individuals. The court noted that it was not minimizing the heinous nature of the criminal conduct or the stark tragedy of its consequences, but the conduct did not fall within the definition of terrorism. The Court of Appeals, that's our highest court in New York, affirmed the appellate division's dismissal of the terrorism convictions and ordered a new trial on the remaining counts. The court noted that the statute did not define the phrase intent to intimidate or coerce a civilian population, but it stated that it should be given its most natural and obvious meaning based on common sense and reasonableness in the context of the purpose and history of the terrorism statutes. Civilian population should be read broadly to encompass a variety of communities, depending on how area is defined and who lives within that territory. Footnote 8, which says, the court noted the dictionary definition of population as the total number of inhabitants constituting a particular race, class, or group in a specified area, or a particular section, group, or type of people living in an area or country, or a body of persons having some quality or characteristic in common and usually thought of as occupying a particular area. The court found it unnecessary to precisely define the term civilian population, but it concluded that even if all Mexican Americans living in a particular area could be considered a civilian population, the evidence did not demonstrate that the defendant committed his discrete act with the conscious objective of intimidating every Mexican American in the territory identified at trial. 1 second while I'm parched. Moreover, the court found that there was no indication that the legislature enacted an Article 490 with the intent to elevate gang-on-gang street violence to the status of terrorism, as that concept is commonly understood. The statute cannot be interpreted to so broadly as to cover individuals or groups who are not normally viewed as terrorists. The court further stated that the legislature clearly did not intend to extend the reach of the statute to this type of crime, and this was apparent by looking at the examples of terrorism cited in the statute. The crimes committed by the defendant obviously were not comparable to those terroristic acts. As in Morales, the question presented here is whether a defendant's act, no matter how heinous, fits within the definition of terrorism as set forth in the statute and as illuminated by legislative intent. This court does not believe that the legislature intended the employees of a company, however large, to constitute a civilian population within the meaning of the statute. Giving the phrase its natural and obvious meaning based on common sense and reasonableness, it is clear that the term encompasses inhabitants of a particular area, or at least a group of inhabitants of a particular race or class living in a particular area. Citing some more case law. Moreover, as in Morales, even if this court were to find the employees of one company to constitute a civilian population, there was no evidence presented that defendant's conscious objective or intent, and that is italicized if you're not watching your screen, conscious objective or intent, was to intimidate or coerce the employees of United Healthcare. The people point to defendant's journal entries found in his backpack as evidence of terroristic intent. But those writings ultimately do not aid the people's argument. The defendant's apparent objective, as stated in his writings, was not to threaten, intimidate, or coerce, but rather to draw attention to what he perceived as the greed of the insurance industry. Quote, and this is, I guess, a quote from his journal, members of the public can focus on greed, end quote. And as an additional possible consequence, to negatively affect the financials of the company. The defendant emphasized that he wished to spread a message and win public support about, quote, everything wrong with our health system. The defendant explicitly contrasted himself with Ted Kaczynski, the Unabomber because he, quote, indiscriminately mail-bombed innocents, end quote, and, quote, crossed the line to terrorist, the worst thing a person can be, end quote. Exhibit A to People's Affirmation in response to defendant's omnibus motion. While defendant's own characterization of his conduct is, of course, not dispositive, where there is no other evidence of terroristic intent, the writings fail to supply that evidence, contrary to the people's characterization. The people presented sufficient evidence that the defendant murdered Brian Thompson in a premeditated and calculated execution. That does not mean, however, that the defendant did so with terroristic intent. And that, my friends, I'm breaking just to say, is the reason why we read the papers. This is the reason why we read the papers, because if you're just reading the headlines, many people are going to be outraged. What do you mean this isn't terrorism? What do you mean they're dismissing the first-degree murder charges against Luigi Mangione? Well, the only way you can get to first degree in New York is terrorism. And this, is, in my opinion, is a very, very well-reasoned decision. And this is explaining to us why this judge does not believe that this is terrorism. And I happen to agree with this decision because once you start expanding what a terrorist is, you know, where does it end? So I'll read that again. The people presented sufficient evidence that the defendant murdered Brian Thompson in a premeditated and calculated execution. That does not mean, however, that the defendant did so with terroristic intent. Notably, the federal authorities, while recognizing that Brian Thompson was, quote, gunned down in cold blood, end quote, did not charge the defendant with crimes of terror, but with using a firearm to commit murder and related crimes, even though the federal terrorism statute served as a model for the state statute. Regarding defendant's intent, the acting U.S. attorney for the Southern District stated that the defendant's goal was a, quote, grossly misguided attempt to broadcast his views across the country. The assistant director of the FBI stated that the defendant committed murder to incite national debates and that he deemed murder an appropriate recourse to satiate personal grievances. See U.S. Attorney's Office, Southern District of New York press release of December 19th of 2024. The people suggest that the element of intimidation and coercion can be met because some United Healthcare employees felt fearful after the murder and some United Healthcare employees received threats. But putting aside that some employees received threats even before the murder, one so serious that investigators traveled to another state to investigate, and every murder has the potential to induce some degree of fear. For example, a random murder in the subway will cause riders to feel fearful about riding the subway. That fails to establish that this was the defendant's intent or that the conduct fits within the statutory definition of terrorism. Using the guideposts of the 7 examples as directed by Morales, defendant's crime, as in Morales, is similarly not comparable to the examples listed in the statute. There was no evidence presented of a desire to terrorize the public, inspire widespread fear, engage in a broader campaign of violence, or to conspire with organized terrorist groups. It looks to me like a comma, but it's period. Here, the crime, the heinous but targeted and discrete killing of one person, is very different from the examples of terrorism set forth in the statute. The examples cited in the statute share the characteristics of indiscriminate killing, which produce fear and terror, whether through bombing or through the indiscriminate shooting of multiple victims. The indiscriminate nature of the shooting or bombing strikes terror into the population and induces a fear not to engage in daily activities for fear of violence. As the legislative findings note, terrorism, quote, disrupts public order and threatens individual safety. The concept of terrorism has a unique meaning that, quote, risks being trivialized if the terminology is applied loosely in situations that do not match our collective understanding of what constitutes a terrorist act. This court need not reach the issue of whether the statute encompasses an act that only involves a single victim, but the court will note that the people's reliance on two of the examples set forth in the statute, the Empire State shooting and the Ari Halberstam killing on the Brooklyn Bridge, as incidents that encompassed only one victim, is misplaced. Those incidents were very different than those presented here. In the 1997 shooting at the Empire State Building, the gunman, who expressed his desire for revenge for the treatment of Palestinians, opened fire with a semi-automatic weapon on the observation deck, killing one person and wounding 6 others. Footnote 10. See Matthew Purdy, Empire State's gunman's note, kill Zionists. In the 1994 Ari Halberstam shooting, the gunman, motivated by a desire to retaliate against Jews, fired shot after shot into a van of Orthodox Jewish students, killing one and injuring 3 others. Footnote 11. Citing another article from the New York Times. The defendant's targeted killing of one individual, although abhorrent and despicable, is not, quote, comparable. Footnote 12. Note that the prosecutor for Grand Traverse County, Michigan, chose to indict a defendant who stabbed 11 people at a Walmart for terrorism because his intent was to bring fear and destruction to a community as a whole rather than to harm specific individuals. Quoting a New York Times article, July 27th, 2025. While there is no doubt that the crime at issue here is not ordinary street crime, it does not follow that all non-street crimes were meant to be included within the reach of the terrorism statute. While the people placed great emphasis on defendant's ideological motive, there is no indication in the statute that a murder committed for ideological reasons, in this case, the defendant's apparent desire to draw attention to what he perceived as inequities or greed within the American healthcare system, fits within the definition of terrorism without establishing the necessary element of an intent to intimidate or coerce. The court agrees with the defendant that the people appear to conflate an ideological belief with the intent to intimidate or coerce a civilian population. While the defendant was clearly expressing an animus towards United Healthcare and the healthcare industry generally, it does not follow that his goal was to, quote, intimidate and coerce a civilian population, end quote. And indeed, there was no evidence presented of such a goal. As the Third Department recently held, we look to the acts of violence in this case within the guideposts of the specific acts of terrorism referenced in the statute, and through that lens, the court declined to loosely interpret the defendant's conduct in that case as fitting within the statute. Citing Parker, as in Parker, I do not sanction the defendant's heinous conduct, but it does not comport with our current understanding of terrorism. Here, the evidence presented failed to establish that the defendant committed the crime to coerce or intimidate a civilian population, or to influence or affect the policy of a unit of government, and therefore the first 2 counts of the indictment are dismissed. The remaining counts of the indictment, including murder in the 2nd degree, are legally sufficient. Defendants claimed double jeopardy violation and request for a stay. Defendant argues that concurrent state and federal prosecutions violate the double jeopardy clause of the United States Constitution and Criminal Procedure Law 40.20, barring prosecution for 2 offenses based upon the same act or criminal transaction. However, as the U.S. Supreme Court has held, where there are 2 sovereigns, there are 2 laws and 2 offenses. Citing Gamble v. the United States from 2019. A crime against 2 sovereigns constitutes 2 offenses because each sovereign has an interest to vindicate. Thus, there is no double jeopardy violation. While it is true that the Criminal Procedure Law 40.20 grants greater protection than that of the state or federal constitution, that bar is triggered only when a prior prosecution ends in a conviction by guilty plea or once a jury has been sworn. Therefore, because neither event has occurred, defendant's motion is premature. What the court is saying is you can argue double jeopardy later after a guilty plea or a conviction. Defendant nonetheless argues that he is prejudiced by concurrent proceedings because he will be forced to litigate a federal case in which he faces the death penalty while the state case is proceeding to trial, and that testifying in the state case may prejudice him during his federal trial, thus implicating his rights to defend himself and against self-incrimination. Does anybody think he's going to testify? I don't. Defendant suggests that the federal case should proceed first, even though the federal and state authorities have agreed that the state case should proceed to trial first. This court is not persuaded that proceeding to trial in the state case first will cause the defendant severe prejudice, and the defendant's claim that any state trial testimony will prejudice his federal trial is merely speculative. Moreover, defendant cites no case law or authority that would permit such a protracted adjournment, as even defendant concedes that the federal case will take several years before trial. The court is also confident that counsel will have the capability to manage an approximately 2-month state trial. They only think that this trial is going to go for 2 months. During the pendency of the several years before the federal case proceeds to trial, defendant's request to stay the state proceedings is denied. There are still murders, grace-based, yes, there are still murder charges in the state case. The only charges that were dismissed are the charges involving terrorism, but there is still murder charges pending. Summary: counts 1 and 2 charging defendant with murder in the first degree in furtherance of an act of terrorism and murder in the second degree as a crime of terrorism are dismissed as legally insufficient. The people presented legally sufficient evidence of all other counts, including murder in the second degree, which is intentional murder in New York. He will not walk. It'd be like you guys are misunderstanding if you think he's going to walk. You guys are misunderstanding. He is still charged with murder in the second degree, which is intentional murder in New York. He's just not charged with the terrorism murder anymore. Thus, the motion to dismiss is denied in all other respects as is the motion to stay the proceedings. This constitutes the decision and order of the court. XOXO, Gregory Caro, Judge of the Court of Claims, Acting Justice of the Supreme Court. Oh, that's interesting. The Court of Claims in New York hears only cases that are brought against the state. For example, if you are a prisoner in a state prison and you are up on the roof doing something such as roofing, I had a case like this once, you sue in the Court of Claims. And so those judges only hear cases against the state. This constitutes the decision and order of the court. September 16th, 2025. Judge Gregory Caro. I happen to agree with this decision. I do not think these were acts of terrorism. I have lived through acts of terrorism in New York City. I mean, New York as my home. And roofing is like, guys who work on the roof. Guys who work on the roof and like replace the roof. I had a client once years ago who was an inmate in a state prison. And because he was a roofer, he was asked to do some roofing work around the prison as part of his in-house work study for prisoners. And so he was on the roof and he fell off the roof and he got injured. So he sued the state of New York. Hi, Osiris. Thanks for being back and for being here for a happy 1-year anniversary to us. Vicky Watkins became a member. Welcome. Welcome to you. Prosecutors issued a statement after the hearing today saying, "We respect the court's decision and will proceed on the remaining 9 counts." The judge has scheduled the next hearing for December 1st. That is going to be the pretrial hearing, which is days before Mangione is next due in court on the federal case against him. He's now 27 years old, Ivy League graduate. He went to Penn. And the AP reports here regarding the hearing this morning. Supporters of Mangione took up 3 rows in the courtroom gallery. As was the case at his last hearing, a few dozen supporters, mostly women, showed up to Tuesday's proceedings. Some were dressed in green, the color of the Mario Brothers video game character Luigi wears, as a symbol of solidarity. And one woman sported a Free Luigi t-shirt. Well, if you were in Norfolk County, Massachusetts, they would not allow you to wear those items into court. Outside, some supporters who gathered across the street from the courthouse cheered and clapped as news of the dropped terrorism charges spread. Mangione earlier pleaded not guilty to multiple counts of murder, including murder as an act of terrorism, in the December 4th, 2024 killing. Surveillance video showed a masked gunman shooting Thompson from behind as he arrived for an investor conference at the New York Hilton in Midtown. Police say delay, deny, and depose were scrawled on the ammunition, mimicking a phrase commonly used to describe how insurers avoid paying claims. And also reminiscent of what happened last week and the etchings on the bullets that were found after Charlie Kirk's assassination. I wonder if he was inspired by Luigi Mangione, Tyler Robinson. Mangione was arrested 5 days after he was spotted eating breakfast at a McDonald's in Altoona, Pennsylvania. I wonder if that employee of McDonald's ever got the reward, because remember they were fighting giving the employee the reward money. The second-degree murder charge in New York State carries a potential penalty of 15 years to life in prison, with the possibility of parole after 25 years. The federal charges allege that Mangione stalked Thompson and do not involve terrorism allegations. U.S. Attorney General Pam Bondi announced in April that she was directing federal prosecutors to seek the death penalty for an act of political violence and a premeditated, cold-blooded assassination that shocked America. So there's that. He's got the potential. He's got the opportunity of 15 to life with the possibility of parole at 25 years. And as we stated, he is currently 27 years old. Thank you, Tracy, for your super chat. Thoughts, questions, comments, concerns? Tara Christine, the juxtaposition of seriousness of the crimes to the supporters wearing cartoon-style costume Nintendo Luigi hats is disconcerting. Yes, Kelsey's in court October 7th, Kelsey Fitzsimmons. You are correct. Everyone is asked to wear purple. And I have some medical information and a new motion or a supplemental motion that was filed on Kelsey Fitzsimmons, which I intend to go over later today. I'm also expecting Bettero's mega motion sometime today because Aiden said that on his bus stop live this morning. So I'm waiting for that to happen. And when that happens, I'll be handling that this afternoon as well. I don't know. I don't know what this has to do with Charlie Adelson at all. Hi, Sven Cometh. Great question. Can they recharge first-degree murder without the terrorism? No, because in New York, maybe you're late. Maybe you're late to class today, but in New York, there are only very slim circumstances under which you can charge first-degree murders. Only certain crimes rise to the level of first-degree killing of a police officer, and other things such as like that, and murders involving terrorism. So first degree, unlike many other states in New York, is very slim. And so the answer to that is no. But that's a great question. Do you think there's enough photo evidence for a quick trial? Well, they just said the trial was going to be 2 months. I mean, for a quick verdict. I mean, there's video of him doing it. They have his DNA. I don't know that there's a question that he did it, but if they get the right jury, he could be acquitted based on jury nullification, because a lot of people seem to be supporting Luigi Mangione because they feel the same way about insurance companies, I guess. Gravel Grady says, yes, I think that the Tyler's Act was a copycat killing. Somebody said in here, can we say unaliving instead of assassination because he was not a political figure? But that's not the definition of assassination. Gertie, can we say unaliving instead of assassination? He was never elected. You mean for Charlie Kirk? I mean, we could say that Brian Thompson was assassinated too. The legal definition of assassination doesn't have to do with the political figure. So I think anybody that is gunned down in cold blood and has been followed and planned and stalked could be called an assassination, especially something that is captured on worldwide television. And I find that this whole thing to be horrifying for our children who have had their feeds flooded with the graphic footage of that and can't unsee it. Charlie Lynn, I agree about insurance companies being evil, but vigilante justice is not the answer. The government is unintentionally, is that what that means? Or intentionally or unintentionally? Because there's a U there, but it looks like maybe you meant unintentionally. Spreading Luigi Mangione's message and increasing support. Thank you, Charlie Lynn. Thank you, VK, for hanging out with me for 16 months and for thanking me. For explaining the papers. We love to look at the papers here. We do. We like receipts. It helps us to understand what the law is and why the judge is deciding what the judge decided. Because like I said earlier, if you're just looking at the headline, you might not understand. Catherine, what do you think will be the sentencing for Luigi? Life, 15 years? Well, he's not convicted yet, Catherine. He's not convicted yet. So I love you. I love you very much. And I'll take your $20 super chat, but it would be silly for me to opine on something that has not even happened. It's going to depend on the evidence that's going to come out at this trial. It's going to depend on what the jury does with it. I don't know a lot about this judge. I do know that he's only an acting Supreme Court judge. So he's sat in the Court of Claims for, I would imagine, many, many years, which is completely different animal. And so he would be in charge of the sentencing, and I just be silly for me to speculate. Depends on what the charges that if he's convicted, what those charges would be. Flo Dude 38 says he will walk. New York is very liberal, like 80%, with that side believing killing for their view being okay. He will walk. I don't necessarily agree with that. Natasha Richardson says, I stay out of political and cult cases usually. So do I usually. But this just broke and I happened to be able to find the decision. So I thought, let's read the decision and just kind of leave it there. Thank you, Connie. Got some sunflowers yesterday out east or whatever day I came back from Boston. I think it was Saturday. And they have these beautiful out on the east end of Long Island farm stands where you can just stop and pick up a whole thing of sunflowers like that for $10 and put your $10 in a little box. It's the honor system, but I love those. Thank you very much. Mashed potato goblin says, I never needed to see CK shot. Horrifying. I thought it was AI at first. He did everything he stood for, but we can't go running around taking people out. Agreed. Gorgina says, the mayor is so dirty to do that perp walk. OMG, Josh Johnson explains everything about that mayor. Josh is the best. He's a comedian, right? I think somebody sent me a video of his the other day on something, and I can't remember what it was, but he's good. Yes, he does still have federal charges. So, Laura, if you didn't catch up on that, rewind. The federal case is going to take much longer than the state case. So, the state case is going to be tried first, and the federal charges do involve the death penalty. And the U.S. Attorney General says she is not backing off of her desire to give or to seek the death penalty in the federal charges against Luigi Mangione. Maureen Francis says, I love that you always have the receipts. Wow, thanks for being with me for 21 months. What is the dumbest thing that you've heard today, Pamela the Camel? Lettuce says, TBH, I'm so confused of how Luigi knew exactly where Thompson would be. He biked down to 56th Street at 5 a.m. And how did he know he'd be walking across to another hotel? Well, I think he was waiting outside for him. I remember when we covered this. I have a whole playlist on that. Well, not a whole playlist. This is only the 4th video. But there was an online sleuth who actually figured out what city bike he used because this online sleuth was able to like track somehow the city bikes that were turned in at a certain location outside Central Park or something such as like that, and was able to track it down to exactly what city bike he used. It was wild. It was wild. Off topic. I think we need to go off topic, Stina, for a minute. Have you taken a look at the Priscilla Presley case? No, you guys told me about it. I haven't had a chance. You know what I did last night? I watched the Charlie Sheen documentary. Did anybody else watch that? It is wild. It is wild that Charlie Sheen is still alive. There are people like Charlie Sheen and Keith Richards who must have some gene. They should be studied at the university level that keeps them alive despite all of the tragic, horrible things that they do to their bodies. Anybody watch the Charlie Sheen documentary? R.I.P. Robert Redford. We're going to take a side quest. Let's take a side quest. Robert Redford, also a graduate of the University of Colorado Boulder, my alma mater. And I think Robert Redford spoke at a graduation, but it wasn't mine. So R.I.P. to the Sundance Kid, which is one of the first movies that I remember seeing and just like having a crush on Robert Redford my whole life. He was 89. He had a good run. He had a good run. I did not watch him on Joe Rogan. Charlie Sheen. Yeah, he's fighting a lot of inner demons. He says he's been sober for about 7 or 8 years, I think, because I don't know when that documentary was filmed. But Denise Richards was on. She was crying. It's heartbreaking. I mean, the fact that she's able to like still maintain a relationship with him and co-parent with him. She met him when he was sober, and then he fell off the wagon during like their marriage, and she divorced him. She had 2 little kids at the time. And then he got into that crazy relationship with Brooke Mueller, and Brooke Mueller is on there too. Oofa. And he had 2 boys with her. And then when Brooke went away, Denise Richards took in the 2 boys also, and they lived with her for like a year. And it's great. Heidi Fleiss was on there. Did anybody watch this? Am I the only person out here who watched this? It's on Netflix. It's only 2 parts. Heidi Fleiss, remember Heidi Fleiss, the madam? She was on there. Wow. It's rough. She's had a rough life. Dragonfly, I know. I watched it. He's going to be the next Matt Perry. Well, he says he's sober. Oh, and Martin Sheen, his father, was very public about Charlie's struggles and really did everything he could and made his struggles public on purpose as an attempt to help him. And Denise does seem like good people. Cosgrove's Reverse Mortgage. And I had to tell you that you have one of the best usernames on YouTube. One of the best usernames on YouTube. Cosgrove's Reverse Mortgage. Chef's kiss. Yeah. Heidi Fleiss was really mad at Charlie for snitching. And the only reason she says that Charlie was caught was because he paid her one time with American Express traveler's checks. Could you imagine? He had no cash. And he's like, oh, will you take my American Express traveler's checks? And she did. And she had the traveler's checks in her possession, still her copies of them. And that's how his name came out. She said his name never would have came out. I never would have given him up. It was very well done, that documentary, I thought. Janine said, I had an ongoing disagreement with my high school bestie over who was better looking. She was Team Redford and I was Team Paul Newman. Tough choices. Yeah, I was a Redford girl myself. I agree, Joy. Brooke Mueller looked totally messed up in her interview. I know. I know. Kylie said, I canceled Netflix, so I'm lame at the water cooler now. Good. Let's tell her more. Tell Kylie more. Whole new respect for Denise Richards, says San Fran. And I think, who did I watch an interview? She did an interview with someone else that I like. And I don't remember who it was. I think it was Bethany Frankel. Did Bethany Frankel do an interview with Denise Richards? I think she did. And man, she's been through some stuff. Let me see. I really like Bethany Frankel. A lot of people don't like her, but I really like her. Yeah, she did. It's on YouTube. You can find it on Bethany Frankel's YouTube channel. And I think, yeah, this was from February of 2024. And she's very open about her toxic divorce and everything else. And now I think she's going through some more stuff with the guy that she's with currently, right? Didn't I read that somewhere? Yeah, Charlie talks about how he and his brother Emilio Estevez used to make all these like Super 8 movies when they were little, like really little. And they have like some clips of these videos and these movies that they used to make. Neenmog, it's our 1-year anniversary. I love you too. Charlie Lynn says I might as well draft a letter. I might draft a letter to the ACLU regarding Kelsey. If so, I'll post a template on X that others can sign and send as well. Oh, Charlie Lynn, you're such a giver. You're such a giver. You're very sweet. Yeah, Bethany Frankel went through a tough divorce too. It took 10 years. 10 years. It's so gross to honor a Nazi. Which Nazi are we talking about? Adolf Hitler? Who's the Nazi in your comment? Georgina 602. That was really awesome to see the Super 8s. I know. Yes, I know. The surgeon wrote to Kelsey's judge. Well, yeah, I saw that. We're going to cover it later. We're going to cover it later. Heather McDonald interviewed Denise Richards on Juicy Scoop. Oh, yeah? That's awesome. Oh, Denise is getting divorced from that guy, Aaron? It's rough. Oh my God, Lettuce, he did everything, Charlie. The worst of all was the crack that he was smoking. He was saying that he used to take like 8-gram rocks, like the size of a tennis ball, and do the entire thing. Cook it up and do it. It was rough. We're hoping the Mega Motion drops today. We're hoping. As soon as I get it, I'm gonna go live. She was timed out for too many deletions today. Or did she just come in here to spread hate? Yeah, we don't do that. We don't do that here. That's why we're changing the subject. I'm Michelle. I cannot stop thinking about Fitzsimmons. Is there anything we can do? Go to court on October 7th in Essex, Superior, and Salem and wear purple. That's what you can do. For now, until I have further ideas. But there was a supplemental filing filed by Tim Bradle, including a letter from the doctor. The judge has ordered the transcript from the hearing on a rush. And hopefully she will reverse her asinine decision, allow Kelsey to be monitored for alcohol intake by urine testing, and let her out of jail again, because we're all horrified by it. Kylie, do you know why they were decided to schedule a hearing rather than just ruling on it as Bradle requested? I think the hearing was already on the calendar for another reason. And so did they schedule another hearing, Kylie, that I'm not aware of? The October 7th date was on the calendar already. Oh, the jury is going to start deliberating today on Josh Hubert in Worcester, Mass. They are deliberating right now. Thank you, Kyle Sharkey, who sends me all the breaking news. That was at 11:36 a.m. So the jury's out on Josh Hubert. How long is it going to take for them to come to a verdict? What do you think? What do you think, you guys, is going to happen in Josh Hubert? He's the guy who threw the 7-year-old off the bridge in Worcester in 2017. Yeah, free Kelsey. You guys have your next cause, and I'm so happy about it. He's charged with Hubert, forcible child rape, aggravated by age, 2 counts of attempted murder, and a single count each of kidnapping a child under 16 and strangulation. And the jury's out. Oh, Bo, are you in court today? Prestige Worldwide. Hi. Thanks for your 20. How would one go about writing to Kelsey letters of support? I think the best idea would be to send them to Tim Bradle's office. I'm sure you can Google Tim Bradle, attorney, and find his office address and mail them there. And then I'm sure that he or Courtney, his amazing paralegal, will get them to her. I know what it's like to suffer with PPD and then go through what she's going through, says Prestige Worldwide. Thank you so much. I think it's a very, I don't know how common it is, but I will say that it is a very horrific condition that a lot of people, including the courts, may not understand. And so thank you so much for your super chat and for supporting Kelsey. And I'm sure that she would love to hear from anyone who has a message of support for her. That's a fantastic idea. And so, Michelle, when you say, is there anything we can do? Send letters of support maybe to Bradle's office. That would be amazing. Something that we can do in the moment if you're not able to make it there. Cosgrove's reverse mortgage says my name was gummy induced. It hit me during your Friday Night Live slumber party with Nurse Kim a couple of weeks back. That's hilarious. I'm so glad that Kimmy and I were able to inspire you to change your name to the funniest one on the tubes of you. Any updates on Aaron Spencer? No, next hearing is going to be in December, and then the trial's in January. I haven't seen anything new come up. I've not seen anything new come up yet. Thank you so much for your super chat. Tina Lewis, not sure if anyone asked yet, but will you be covering Tyler Robinson hearing today? It's at 5 Eastern, and I think it will be televised. I have a feeling that I may be neck deep in covering Bettero's mega motion. And so I don't know if it's going to be televised, but if it is, I can't commit to it right now, Tina. I just can't. Sorry. I got a free Turtle Boy too, you know? And the hatred that I've seen spewing from mostly one side on this Tyler Robinson case is something that my soul just cannot handle. So I don't know. I can't commit to it. Thank you for your super chat though. Gen X Chick, hi, I'm at Alive. Yay, I love you. Oh, I love you more. I love you more. Mega Motion, you say? Well, Aiden was doing his Bus Stop Live this morning and he said it's happening today. So I don't know. It's not televised, says Alana K. Not televised. It's in Utah. Sometimes Utah allows. Thank you, Cast Me Out 420. Tim Bradle's address, 15 Broad Street, 240 Boston, Mass. 02109. In case you want to send Kelsey a letter of support. Speaking of Utah, that is where Robert Redford died, in Sundance. He founded the Sundance Film Festival. And when I was growing up, my family had a ski house in Park City, Utah. So I spent a lot of time in Park City and I love it there. Love it, love it, love it. Thank you, that girl. T, I'm outraged by the Kelsey case too. It triggers me. I know. Triggers me too. It's triggering. It's triggering. Better is magic, says Swiss Miss. I can't wait for the mega motion since I have questions. It's a virtual court proceeding, so we can go on the Zoom, or people can go on the Zoom if they want to. Danielle says, I can't believe all of the redacted. Is the motion already out? Is it in my inbox and I haven't seen it yet? The Josh Hubert trial's happening. There are a lot of redactions in it. Yeah, well, there has to be, because a lot of the stuff that they're going to talk about is under a protective order and they're not allowed to release that. And remember, the judge refused to lift the protective order. And so it has to, a lot of that stuff has to be. Kendra, his lovely paralegal, Bradles, is Courtney. People are sending me emails that they're blocked on the channel. If you're blocked, you need to send me the link to your channel. Your username doesn't do it for me. I need the actual link to your channel. YouTube has been blocking people. Sua sponte. Sometimes it happens. Is there anyone live tweeting on Josh Hubert? Because I'm dying to know what that jury's going to do, because we're not allowed to see it. Oh, and just as I say that, because I've been waiting, I told you I ordered the court audio for last Friday's trial on Hubert. I just right now got the audio from Friday. Natasha Richardson, I've been blocked because I'm a biatch sometimes. Yeah, all you gotta do is be nice. That's all you gotta do is be nice. Just be nice. If you come in here to try and stir the pot and cause trouble, the mods are pretty serious about, people coming after me and coming after each other and doxing people. Judge Doolin redacted a lot of things in the mega motion. Okay, Danielle, are you telling me that it's out? I don't think Judge Doolin is doing the redacting. I think that the attorneys are doing the redacting. Like, talk to me about where you're getting your information from. Are you saying that Aiden said that this morning? Right. He said that there were redactions. Right. Okay. Well, we don't know because we haven't seen it yet. But the judge isn't doing any of the redacting. Okay. All right. Saying that's, how do you know if you're blocked? I don't know, because nobody else would see your comments. I think that's how you would know. Here's Olivia. Olivia is currently still redacting stuff because Olivia Nile is on the team. She's on the team, the Turtle Boy defense team. And we love her so much. Thank you, Olivia. I don't like when people spread misinformation. Olivia, in case you just tuned in, the jury is out on Josh Hubert. How long do you think they're going to be out? What's the over-under on that? Patricia says, I wonder if the judge is menopausal and that accounts for her bad mood and attitude. I never had a bad mood and attitude. That's a little I don't know. That's kind of an odd comment. Is everyone who's menopausal? Does everyone who's menopausal have a bad attitude and in a bad mood? I mean, I don't know. Oh, thank you. Nothing nefarious here says it was so much fun seeing all the different perspectives on the Wilbur that you all did, and to see his smiles on your faces. Oh, that was so much fun. I'm so glad you were able to make it. I hope I got a chance to meet you. You think the jury's going to be out for 2 days, Pure Duckery, on Josh Hubert? That's interesting. Yeah, if you didn't watch my stream from yesterday, they are trying to go after Karen Reed again. We did 2 yesterday. We did stream in the morning about the new charges that Cosgrove wants to bring against Karen Reed, and wants to unlock her phone, and wants the passwords, and wants to extract her phones that he seized all the way back in January 2024. And also, we did a show in the afternoon on Brian Walsh and Miles King, that hearing, and then we did a segment on Brian Walsh losing his appeal on the motions to suppress that were denied. So if you did not watch that stream on Karen Reed from yesterday morning, go back and watch it. And you might want to make sure while you're here and while we're still talking that you have your notifications set to all. That is something else that commonly happens. People think that they have their notifications set to all, and they do not, in fact, have their notifications set to all. They're like personalized or something, because YouTube has a weird default. The default is personalized. Olivia, you said something great, and I just couldn't find it. The new evidence in Joshua Hubert that you discussed is disturbing. The phone alibi data and the third DNA contributor. What the heck? Well, actually, I don't know if he was a DNA contributor. He was also tested. His DNA was tested. This third person who's been unnamed by Mass Live, because actually Bo was there in court, and so they did say the guy's name. He was the girl. Remember that the girl went to a house after she was able to swim 100 yards after he threw her off the bridge into Lake Quinsigamond. The woman whose house she went to called this third man before she called the police. I have questions. And then he gave a DNA sample, and they tested his DNA, her father's DNA, and Joshua's DNA against the seminal DNA. And the only one who matched was the father. Because I guess there was another contributor, but the sample wasn't enough to test. Get to work, girl. Keep you doing your redactions. Cheryl with an S, boots for Karen Reed and Turtle Boy. Count me in on 10-7. All right. I'm so happy, you guys. Thank you for your super chat. Oh, hi, Melanie. You're my favorite, says Corgi Life. No, you're my favorite. You're my favorite. Good. Get your notifications working. What did I miss? Look at Daria coming in an hour and 15 minutes in. What did I miss? Well, you're going to have to rewind, sweetie, because I think we're almost wrapping here. You missed that the New York State judge and the state charges against Luigi Mangione dropped the top 2 charges involving terrorism. All of the remaining charges remain, including murder in the 2nd degree, intentional murder, which carries a 15-year to life penalty in New York with possibility for parole after 25 years if there's a conviction. He is also facing federal charges in which the feds are seeking the death penalty. However, the state charges will be tried first because that will come up sooner. Federal court takes a long ass time. Sarcasm. Hey, Melanie, I found you through Next Witness. So glad I did. You have a very calm presence, even with snark. I love it. Oh, thank you. That's sweet. I'm so glad. I love Next Witness. They do a lot of very funny, like LawTube compilation videos that are fun to watch. It's fun because I don't get to watch a lot of other people's shows. And then it's so fun to see. Oftentimes, our reactions are very similar when we are watching the same testimony. Thank you. Miss Home 66 says, I have loved Redford my whole life. Sad and happy day. Agreed. Thank you for counting you in, Cheryl, with an S. I have the documents for Kelsey Fitzsimmons. I'm going to do them in a special stream that is just for Kelsey. Because right now, this title is Mangione. The thumbnail is Mangione. I want to talk to Nurse Kim about Kelsey's injuries, and we're trying to plan to do something together regarding that when Nurse Kim is not at work. And so we will cover it all together. Okay. All right. Any thoughts, questions, comments, concerns before we wrap this one? But you're going to want to make sure you have all your notifications set because I'm going to come back if the mega motion drops today. The verdict comes in on Josh Hubert. And there's going to be other things to cover today. So you're going to want to come back and you're going to want to make sure that you have your notifications set. Somebody sent me the Kelsey Fitzsimmons inmate address. I don't anticipate she's going to be in jail for much longer. So I think my suggestion of sending mail to Bradel's office is a better one because then when she gets out of jail, which I suspect she will soon, he can deliver them. All jail mail is opened and read. So, I don't think anybody needs to do that. I don't think she's going to be there that long. By the time you get your letter or your card out, she might already be home. So that's my suggestion. Do with it what you will. Guide your actions accordingly. Alan and Elizabeth were just admitted pro hoc vice again. That's good. In the civil case, in the wrongful death case, that's good. That means that, all the nasty things that Judge Cannoni said about Alan Jackson had no bearing on the new judge's determination or decision on whether or not to let him come in on pro hoc vice. Brother counsel was asking for me to send him the documents to go over for Kelsey. Did he tell you to ask me to send? He has my email. He can reach me directly. Are you kidding? Are you kidding me? It's like when people send me messages like, can you forward this to Betero? Can you forward this to the Glare? Can you forward? No, I'm not your secretary. I'm not your secretary. He knows my email. Martin knows my email. If he wants something, all he has to do is email me. I'll happily give it to him. That's hilarious. Hi, Nicole. I loved Legal Eagles. What's Legal Eagles, babe? Thanks for your deuce. That's hilarious. He said he can't find them. Okay, Ryan, did he tell you to come into my chat to ask me to do a favor for him? Like, that's just wild. Christina's like, hey, Mel, can you tell Turtle Boy to call me? One time, and this is the joke, this is the running joke. Somebody once went like really nasty about this, that I was so mean to the chat. Somebody once sent me an email and said, and I say that I read all emails, but I can't respond to all emails because I have my email in the show notes. If you want to email me, you can. I can't always respond to them, but I do read them. Somebody once sent me an email and said, I need you to buy a plane ticket for my 5-year-old son in California, fly to California, pick up my 5-year-old son and bring him to this South American country, she says. And then in exchange, I will give you 10 acres of land. And then I need you to buy plane tickets to return my son, or, for a couple of months later. I was like, I'm sorry, what? I'm sorry. Really? Is that what I do now? Now I'm doing favors. I'm picking up kids at school for people, forwarding documents to, their secretary and all kinds of other. You can't believe the asks that I get, including, here are all of the documents from my case. Can you review them and tell me what you think? No, I'm retired. I can't represent you. I can't come to whatever state you live in. I would love to. I really would, but I just can't. And the only way to express that fully is to say,
hello.
Hello. Hello, I'm here.
that's the only way I can express this fully. 10 acres. 10 acres and some veneers. Yeah. I'll give you some veneers. That would be fantastic. I would love veneers. Actually, I wouldn't. I think they look so fake. They're like chiclet teeth. They're like Matt McCabe chiclet teeth. Trish says, I'm so happy to be here. We love you, Melanie. No, I love you guys more. Here we go again.
Hello.
Hello. Hello, I'm here.
It makes me laugh every single time. It makes me laugh every single time. Wait, hang on. Peter Steele, get over yourself, Melanie. He didn't ask you to do that. Who didn't ask me to do what? That person didn't ask me to just send documents to brother counsel? I'm sorry, what are you talking about? Get over yourself, Peter Steele. Bye. He just said, didn't I just put up a comment that said brother counsel asked us to ask you to send you documents? Did I misunderstand that? Was there something that I misunderstood, Peter Steele? Oh, thanks so much for coming. Enjoy your trip. I'm out of here. I will see you soon. Today, later. Okay. Get over yourself, Melanie. Yeah. Okay, Peter. I'll do that. I'll just take a time out and go get over myself. All right. I'll see you soon. Peace out, because we're going to come back later. Oh, hang on a second, because look at Joy coming in with another super chat. Mel, I was angry as heck for my 10-year-old. My 10-year-old menopause. My laundry tripled because I changed 5 times a night. I spent half of my days with my head in the freezer, hung my head out the window like a dog. Oh my God, I'm so sorry. Did you go through menopause for 10 years? Or you're saying you had a 10-year-old when you went into menopause and you were very angry at your 10-year-old when you were going through menopause because you had your head in the freezer? Because you didn't go through menopause when you were 10. I don't think that's what you mean, but I sympathize with you. I'm so sorry. Not all Peters are Peters. Says Peter Silva. I love you with all of my heart, Prestige. Not all Peters are Peters. Yeah. Okay. All right, guys. Thank you very much, mods, for what is oftentimes vitriolic subject to cover today. So we tried to lighten up at the end, and I will see you later. I have some driving to do because I am the mommy Uber, as you know. And so I will see you soon. Hopefully I'll try and schedule it with enough notice. If I schedule it with more than a half an hour notice, you guys should get a notification if you have it set properly. But if you don't blame me. Just keep checking back. Okay. Hopefully it'll pop up when I am going live, and I will. Block Island is packed. It is in season, Mitchell. It is in season. It is so beautiful there. All right, you guys. Stay cool, stay kind, stay classy. If possible, if you can. And if you go on somebody else's live show, try not to be a dick. It's not that hard. Peace.